since the session is entitled Patent Assertion and Litigation, I'm going to talk about the focal point of patent assertion, namely the USPTO. And I'll address, first off, the elephant in the room. Why is this talk appearing in this session? And that, I believe, is because I initially submitted another paper for Ipsc, and the summer was dragging on. I realized I wasn't really making progress on that paper, so I said, well, I can present this. He said, that's fine. But I don't think they retooled the session I was put up. But of course, you know, the USPTO, and particularly with our new PTAB proceedings, is viewed as one response to some of our concerns about patent assertion and litigation. So that's my one tie-in, I think, to the general of this. Okay. The basic idea of this paper is going to be a relatively short symposium paper coming out next year, is that we have a USPTO that's not your grandmother's USPTO. There's been a very substantial growth in this agency in terms of its budget, in terms of its employment numbers over the last few decades. Of particular note for the purpose of this talk, in terms of the proliferation of post-issuance proceedings. Before the 1980s, we didn't have any re-examination proceedings before the USPTO. We did a reissue was available, which had some aspects like a re-examination, but we didn't have any of these post-issuance proceedings like ex parte re-examination, ex parte review, post-grant review, and cover business method review that we now have. So we have an agency with a great number of new institutional responsibilities, and this naturally has led to a lot of questions about the proper relationship between the USPTO with all these new proceedings and another sort of new institution that was created during the same time period, namely the Federal Circuit, as well as the courts more generally. So you have concerns about the relationship between decisions of the different branches here. As many of you presumably know, the Federal Circuit has recently made clear its position that the USPTO, through post-issuance proceedings, can effectively abrogate a final judgment of liability by Article 3 courts. So the Federal Circuit aren't thrilled by that, but that's the situation we now have. In addition, we of course have these questions about preclusion, which some of you bring on here between USPTO proceedings and court proceedings. We have issues with proper standards of review and what level of deference should be given to prior USPTO judgments or positions. Okay. And the PTAB, which is the new, sort of newly constituted Patent Trial and Appeal Board, replacing the former Board of Patent Appeals and Interferences, has been at the center of many of these debates. So we have an agency with a lot of new powers and responsibilities. It still, in many ways, is a quite limited agency, however. The USPTO does not address infringement questions. Infringement suits are still just being channeled through the district courts and the International Trade Commission. Also, it's an issue of current controversy. The USPTO is still applying this broadest reasonable claim construction even in its post-issuance proceedings. And this limits the extent to which the claim construction it's doing is going to influence or determine what the courts later do, because the courts are going to be looking for the most reasonable claim construction from my view. And then somewhat notoriously, the USPTO still lacks a grant of general substantive rulemaking authority, which the Federal Circuit has read to mean that the USPTO doesn't get Chevron deference on issues of substantive patent law, on, say, the interpretation of what non-obviousness means under the Patent Act. That's still an area where the courts have primary interpretive authority. Now, with the generation of the PTAB and these new post-issuance proceedings, we have seen a new level of formality in the adjudicatory proceedings before the USPTO, greater approximation in some ways of court-like adjudicatory proceedings, which have been associated in other agencies, at least more formal adjudicatory proceedings, with a kind of interpretive authority that can give this high level of Chevron deference. And so some scholars, including Melissa, who's in the room, have argued that these will provide grounds for, and a route for the USPTO to get Chevron level deference for its interpretations of the U.S. Patent Act. So I never bought this argument, and I may give this paper some further exposition of why I don't buy it. I'll talk about that a little here. First, for those of you who either have mercifully forgotten their administrative law or never took administrative law, Chevron is this case for the Supreme Court, which basically said that agencies, when interpreting their own organic statutes, the statutes creating them, or statutes which they're specially entrusted with administering, need a very high level of deference for their statutory interpretations. That high level of deference means that basically if they have a reasonable or permissible interpretation of statute, there's some verbal formulations, the courts should accept that as binding. And not only are the agency interpretations binding in a sense on the courts, but the agencies have the ability to overrule prior authoritative court decisions. That was a later decision by the Supreme Court in that regard, which is a very powerful tool. It was one incentive for me in a prior paper to argue that the USPTO should be given, in my view, substantive rulemaking authority with regard to subject matter eligibility, just so they can try to clean up the mess that the Supreme Court has created and seems to have no interest in ever bringing true rationality itself. I mean, that aside, so Chevron is a very high level of deference. It could be very useful for an agency. On the other hand, not all agencies will get Chevron deference, so they won't be able to, they don't necessarily even use that authority all the time. And that was highlighted by a Supreme Court case, Mead, which actually came out after the Federal Circuit had initially determined the USPTO didn't get Chevron deference, but to some degree vindicated, I think, the determination of the Federal Circuit after it. So this is one where, at least if you think Mead was right, many people don't, the Federal Circuit might have actually gotten something right in administrative law. Okay, so Mead raised this question of whether Chevron applies, and it gives us a sort of Chevron two-step that precedes the Chevron two-step. We have two requirements for Chevron level authority applying. One, that Congress has granted this kind of interpretive authority to the agency, and the agencies actually exercise that authority. So a congressional grant could be explicit, as happens, say, with the Immigration Acts and the Attorney General, where Congress has said the Attorney General has the authority to issue binding interpretations of the immigration laws. Often it's implicit. In Red say if there's a general grant of rulemaking authority to make, issue whatever rules are appropriate to implement and to clarify the powers of the Act, that is seen as carrying this kind of interpretive authority. The Supreme Court has also suggested that providing for relatively formal adjudicatory procedures or notice and comment rulemaking can also be a basis for interpreting this authority. This has been a ground for, say, Melissa or Artie Rye's arguments that the generation of the PTAB with new, more formal procedures like post-grant review can be read to have provided this sort of authority. Okay. Once you have the authority, you still have to have exercised it. It doesn't mean that you could have an examiner go out of cocktail hour and take a position on the meaning of the Patent Act, and that's going to bind the courts. Even if the USPTO director does that, it's not necessarily going to bind the courts. You have to use some sort of procedures, generally that give a signal that you've done what Congress thought you needed to do to exercise this authority, and that the agency actually meant to do it. Okay. Why don't I think that we have this with the PTAB? First, with regard to the first prong, I think there's a little evidence that Congress actually granted this authority. I think in legislative history, we did have an effort at one point to insert a general rulemaking, to give the USPTO general rulemaking power. There was a reaction of the patent community against this, in part, I think, because people were worried about giving this kind of interpretive authority to the USPTO. And it was dropped, and after that, the USPTO was even disclaiming any interest, all bizarre, getting this rulemaking authority They were doing that publicly, although I happened to be on a panel with Dave Kapos at the time, and I told him I was arguing that the USPTO should get substantive rulemaking authority with regard to subject matter eligibility, and he said, I'll take whatever I can get. But publicly they were saying, we don't even have interest in having additional power. Well, there seems sort of little evidence that Congress was meaning to give that. Another reason, another bit of evidence that suggests, I think, that Congress wasn't viewing the PTO, even with regard to PTAB proceedings, as getting this kind of interpretive authority is because in provisions for something like post-grant review, the Congress did something which is a little different from what you would anticipate under provisions for formal adjudication under the APA. The APA, for formal adjudication, as in, say, the ITC, you would have a trial by an administrative law judge, and then an appeal to, quote, the agency, which the APA views as the heads of the agency, namely the commissioners of the International Trade Commission, and that's going to give you a decision by the agency to which, under appropriate circumstances, but not with respect to the FTC itself, as patent laws talk about, you might get a decision by the agency that would get Chevron deference. Instead, what the Congress provided for was appeal directly to the Federal Circuit, not to the director. So the Federal Circuit is put in the position to some degree of the agency as it would normally, as appeals would normally be structured in formal adjudication. Okay, so this to me also suggests that the Congress wasn't thinking of the USPTO as getting this new interpretive authority. In fact, in describing post-grant review, one senator was describing one of the purposes of the PTAB was to allow early certification of issues to the Federal Circuit. Certification is something usually uses terminology to say you're sending this to the highest interpretive authority on the issue, often state Supreme Courts is where it's thought. Okay. Now, the PTAB also, independent of this, even if you thought there was some grant of authority to the agency here, I don't think the PTAB is properly understood as the agency. And even the PTAB and USPTO don't seem to view the PTAB as the agency, because for PTAB opinions to become precedential, not only does the PTAB have to vote to make it precedential, but the director separately has to agree to that. Which suggests that there's not a sense that the PTAB has the authority itself to create binding interpretation. Nonetheless, as anyone who's looked at this area could say, Mead is not the clearest of opinions, and so you can try to find some sort of analogies to other agencies. The best analogy I've found for the PTAB for a kind of agency body that gets Chevron level authority is the Board of Immigration Appeals. I argue this isn't a great analogy, however, because with regard to the BIA, I think the most important selling point is we do have, as I mentioned before, this very clear statutory branch of authority to the Attorney General to create binding interpretations of the immigration laws. And the Supreme Court has taken the view that the BIA is the Attorney General's delegate with regard to this authority. So the kind of Mead step one issue seems resolved in this way, whereas that's, for me, a key barrier with regard to the PTAB. Okay, well, the paper nonetheless is talking about powers and opportunities of the USPTO as prime mover. And one of my major points, which I'm coming back to here, so Marty was saying, he didn't know what I was presenting, but he was saying he was going to complain that Golden, you presented this paper 3 years ago. And to some degree, with my punchline, I have, which is that I don't think we have to worry too much about the lack of Chevron deference here. I think people make too much of a fetish of Chevron deference in administrative law, and now it seems to be crossing over to patent law, although I guess that's sort of harmonization across the law, which the Supreme Court likes to encourage. But agencies manage to operate reasonably well in terms of implementing statutes. There's always certain axes. For decades before we had an opinion, a Chevron opinion and a Chevron framework. You can work reasonably well, actually earning the respect of the courts for your decisions and opinions under something called a Skidmore framework, that is a sliding scale of deference. And beyond that, the USPTO has opportunities as the first mover or prime mover as I describe in this paper, to really shape the debate and the agenda of patent law. They did that a bit, although perhaps to the chagrin of some, in the ex parte Lundgren case, which is an early BPAI decision of the last decade in relation to subject matter eligibility, where the BPAI rejected a technological or didn't adopt a technological arts test. And then there was a concurring opinion which suggested something that the Federal Circuit later adopted. It was only in place briefly, which is really a machine or transformation test for subject matter eligibility. So I think this ex parte Lundgren opinion shows how by really engaging in careful consideration of issues and articulation of arguments and reasoning, the USPTO can help shape the terms of debate in a way that can be influential with the courts. And we've seen this with rulemaking, publication rulemaking as well, in the context of the utility guidelines, where the USPTO really adopted the position on specific and substantial utility with regard to ESTs, and some fact-finding, which provided later grounds for Federal Circuit deference and adoption of that position in the last decade. I think the USPTO can use its PTAB proceedings to engage in that sort of decision-making, which is more likely to have influence in the courts. All right, with that, I'll close and open this up to comments and questions.
So, I was wondering, with the lack of internal appeals, like the fact that you just have these administrative patent judges and not the ALJ going to the commissioner, first thing I was wondering is this sort of an observation you're making, just looking at things we tend to see in formal proceedings, or is there somewhere that I'm not remembering, like a case or in the APA, that says that that's a meaningful distinction? I think that's the sort of first part of the question.
Yeah, so I think, what I would say first of all is that generally when you're talking about Chevron deference, you're talking about deferring to the agency.
Right.
And so part of what I'm thinking about, looking at the APA and how things are normally structured is who is considered the agency here. And what you do see reflected is that the trial adjudicator, unless it is the agency, because the agency under formal adjudication does have the power generally to sit as the trial court, that individual adjudicator is not considered to be the agency. But you're right that there's nothing. I don't think I'm not saying there's a hard rule here. This is why the BIA situation is interesting, because the court. I have never actually spent more time than I expected to do this summer learning about immigration law and proceedings, because I'm trying to figure out what the BIA is, why it exists, and why the Supreme Court seems to think it got Chevron deference would be easily was somewhat complicated. But there the court said that, look, there is this delegation of authority to the Attorney General, which is somewhat interesting in itself, to be the authoritative interpreter of the immigration laws, as opposed to, say, the head of Homeland Security, etc. And the BIA has been delegated authority. There's sort of an interesting rule issued by DOJ here that essentially makes the BIA the delegate of the authority of the
So just a really quick follow-up. One thing, what you're saying is making me think of, maybe you could make the argument that the APJs are essentially employees. I mean, obviously, inferior officer versus employee is in the appointments context. But you can make the same type of argument. You don't usually give formal adjudicative authority to employees.
Well, so it's sort of an interesting. So this is actually, I've had this interesting exchange with Artie, and Artie was saying, well, look, but the director could also pick whoever sits on one of their panels, so the director could manipulate the process. This undercuts part of the argument that this is like formal adjudication. That's the whole basis for, the sort of initial basis for why it was said that creating these proceedings meant you could get Chevron deference. So I think tends to be an internal tension to the extent you say, well, these are really just sort of the pawns of the administrator. It's not really formal adjudication. It sort of undercuts the whole basis, which is this one line in need, which says when you have formal adjudication, that kind of is evidence for this kind of delegation of authority. But it's kind of the
I guess I want to try to figure out exactly what you think is most important in determining whether the agency gets, or the PTAB gets Chevron deference. So let's just hold constant the fact that the PTO doesn't have substantive rulemaking authority. Is there any sort of administrative organization, any organizational chart you could draw that would lead you to conclude that Chevron deference is warranted? Because I'm having trouble coming up with an agency that gets Chevron deference for any of its activities, formal adjudication or rulemaking, that doesn't have substantive rulemaking power. I mean, the classic formal adjudication agency is the NLRB, but they have substantive rulemaking. ITC. Okay, so John, what do you think? Is there an organization?
Yeah, well, I think, I don't have any other example. I mean, it's one thing that's been interesting in this area is, of course, we have this massive literature on Chevron deference and Mead, and it's written at a high level. It doesn't go down and really look at the nuts and bolts of how various agencies operate. But yeah, it does. I don't know. I mean, I think as I said, this goes to the point partly that the stumbling block is the first one. I could see it doesn't seem impossible. You could say you had no rulemaking authority, but you have created an adjudicatory procedure through which the agency can operate. It's just it's hard for me to see the evidence here, and hard for me to see how just based on the PTAB procedures alone we can infer that. Melissa.
So I wanted to push on like a couple things. Like, yes, somewhat following that, I'm curious of what you think any grant of formal adjudication can carry force of law, or what sort of characteristics that has to have. And sort of here when you're saying it's not, PTAB's not the agency, right? Like sort of certain part, like so are you, what about precedential opinions where the director sort of signs on, or the fact that, right, it says in the statute PTAB can be the administrative patent judges along with the director of the commission. And I know they haven't done it in PTAB, but before, in re-exam or patent denials, there have been some cases, right, where they issued an opinion and then they called it back, right, and they put the director, and then they switched what the opinion came out.
Yeah, well, I do say in the paper that, I do think the best case for the PTAB would be the precedential opinion. But the problem right there is it looks a bit like a bootstrapping, like we created our own proceedings to create precedential opinions, the director chimes in, and then we're going to infer a congressional intent to grant this authority on the basis of that. It seems a little strange to say that the agency creates the power there. And the other problem is if you think of the classic sort of administrative law jurisprudence, the sort of Morgan rule that he who decides must hear. This looks like a little too much of an informal process, the current presidential process, to say that the USPTO director is acting in a way analogous enough to a formal adjudicatory proceeding for us to infer this authority. But I do think these help create somewhat stronger cases.
Thank you.